Chief Justice Rabner, Honorable Justices of the Supreme Court, Judge Brandt, and all attendees today, good morning. Thank you for the opportunity to join you today in this very important discussion, and thank you for recognizing the important role of the business community in this important discussion today. My name is Michele Siekerka. I'm the President and CEO with the New Jersey Business and Industry Association. The NJBIA is a member organization representing approximately 9,000 employers across the state of New Jersey. Everyone from the corner pizzeria to the 1,000-employee call center to the biggest utilities, hospital systems, and largest corporations in the state of New Jersey. Collectively, they employ over 1 million employees across the state of New Jersey. We are, in fact, the largest business association of our kind in the nation. And when we wake up each and every day, we advocate tirelessly on behalf of that business community for an affordable and regionally competitive business climate right here in the state of New Jersey. We conduct in-depth research and analysis on economic trends, workforce trends, and provide products and services to keep our members' cost of business down. As an attorney by trade, and one that served before in practice this court in my younger days, I thank you for the role you play as justices each and every day as an important part of policymaking. Your significant role as an arm of government in policymaking and the operationalization of our policy, our laws, our regulations, and our rules of conduct that affect our citizens, our business owners, and our economy. Issues that you're addressing today regarding implicit and unconscious bias on juries is a critical issue, and one I'm thankful that you began the journey on, and again, that you included the business community along on this journey. I've been asked to testify today on a very narrow aspect of this, the impact of jury impaneling and that process and the concept of oversummoning of New Jersey employers and the impact it may have on them and our economy. There is no doubt that any time an employee cannot appear for work, it is a burden to their employer. But I must say, there is not an overwhelming yelling out there or yearning out there from the employer population saying that this is a concern or a problem. However, when I heard yesterday during the discussion, or Wednesday, that over 10,000 individuals summoned never reach the jury box for questioning, I did take pause. And of course, any impact that there could be falls disproportionately on small businesses where the absence for work for just one day, a few days, or several days can disrupt the workflow, daily projects, and affect customer service. And in some instances, please think about a small business owner called to serve. It could mean having to shut down completely while the process plays out. In doing my homework for preparation today, I was reminded that in many New Jersey counties, jurors are on a call-in system. I've been subject to that myself. And that appears to limit the actual need to show up every day during service. And in some cases, people need not show up at all over the course of their service. And where the use of technology might not be maximized to that extent or the best extent possible, the further use of technology to keep people from prematurely being brought into the courthouse and away from their workforce to sit in a wait and see mode should be utilized. And it was very heartening to hear this morning that we have second to none technology for New Jersey's judiciary. I'm glad to hear that. I'm glad to see investments continue to be made because I do think that is an important part of the solution to this situation. I am not sure if a juror utilization survey has been done here in the state of New Jersey, and what do I mean by that? For example, in California, one was conducted in 2011, and the express objective and purpose of that juror utilization survey was to reduce the number of unused jurors and increase judicial confidence in their ability to impanel juries from smaller panels, as well as to identify strategies to reduce the waste from unused jurors on those jury panels, both as a courtesy to the prospective jurors and to conserve valuable court resources. The system seems to be at least the intent in holding this conference today in part, separate from addressing the issue of implicit or unconscious bias and peremptory challenges. In conducting their work, the California Joint Working Group on Jury Administration rejected a cookie cutter approach for the entirety of the state and did not seek to establish a single optimal panel size for all superior courts across the state due to the diversity of different businesses, very similar to here in the state of New Jersey. Their intent was to develop panel size guidelines based on actual historical needs in certain pilot project counties. To develop those guidelines, as was done in the study, individual courts generated reports in their respective jury management systems to obtain information about the number of jurors used from each jury panel sent to the courtroom for jury selection over a specific period of time. And as a result of that work, the percentage of unused jurors declined by 10% over the average, and collectively they found could reduce the number of juries sent to the courtroom by almost 80,000 jurors per year. potentially saving the courts nearly $2 million and jurors and their employers an estimated $57 million annually. Pretty compelling numbers. I'll note that this process was wholly separate from any consideration of peremptory challenges. Now, if our New Jersey Administrative Office of the Courts would conduct, and perhaps is considering conducting as part of this process, a jury utilization study, I think that that would be a great part of this. And I would encourage that that be considered. And again, I'm not aware if one's been done before, but certainly suggest that it be part of this process. And in fact, a way to look to manage the jury pools in a different manner before, at least in congruence with consideration of peremptory challenges as a way to drive down pool numbers. Now, that may not address the issue of diversity of the pool being summoned, but to that end, we need to be conscious of the barriers to serving, as has been discussed yesterday, Wednesday, and today. Before we consider, though, placing any additional burdens on our employers to supplement either income or time off potentially lost, I suggest we again don't look at a cookie cutter approach or a one size fits all. Recall that the small business, and think of the frontline worker versus their company versus those companies who already can and have the means to provide paid time off for their employees. We can do a means test as a process to ensure those jurors needing a further subsidy in order to serve can be identified and address that accordingly. Perhaps a juror compensation fund that fairly compensates jurors for their time of service, where they may otherwise suffer financial hardship if they do so. But at the same time, equalization, and again, mean space of reimbursing a business or an employer who otherwise might be burdened in the same manner. And then perhaps that employer can provide that paid time off to their employee in order to serve. Regarding peremptory challenges, and on one final note, while this process today is geared toward criminal trials, I think we have to be mindful of the fact that whatever the outcome, it will surely bleed down to the civil cases as well. We as lawyers like the slippery slope. In this regard, and on behalf of the business community, we must be assured that a business employer sitting at the defense table of a civil trial has the same right to a jury that is free from prejudices. While those prejudices can take many different forms, for example, a disgruntled customer to an inherent or implicit bias for the person representing the employer sitting at the defense table on a given day, the concept is still the same. And those defendants need to be assured of a fair and impartial jury. Not only that may be about implicit bias, but any type myriad of reasons why there could be prejudice that day. In summary, there's absolutely must be a balance between judicious expediency, trial fairness, while also taking into consideration the impact on those called for service, either directly because of the burdens imposed on them, or the burden on others affected by their appearance, such as the employer because of the loss of them in the workplace. This last consideration might be less about peremptory challenges driving the ability to manage the oversummoning of the jury panel if we haven't considered that type of analysis already, which may prove to be a great place to start, narrowing the issue that you're considering today, and one that I've been asked just specifically to speak so. And regarding consensus, and please keep the employer community at the table as you continue your journey down this path. We are a problem-solving group, and we believe in comprehensive solutions that can be helpful to this cause. Thank you for the opportunity to be part of this discussion today. We look forward to working with you, and please thank you for the continued work you do each and every day on behalf of the citizens of the state of New Jersey. Thank you.